Let's continue and let's get an overview on some laws that provide broad-based protection for applicants and employees. The 1964 Civil Rights Act is a major piece of legislation that affects virtually all employers in the United States. Originally created to ensure that the integration of African Americans into mainstream society, the law prohibits discrimination on the basis of race, color, religion, sex, and national origin. Some forms of discrimination on the basis of religion, sex, or national origin are permitted if they are bona fide occupational qualifications, which is a concept that you studied from the textbook. Title VII is the foundation on which all other workplace non-discrimination legislation rests. The law has been amended throughout the years to provide additional protection and rights to applicants and employees. Be sure you become familiar with such amendments, which you can find on pages 30, 31, and 32 of your textbook. Also, details on these laws and others will be shared with you when and if you take the HR and the Law class, part of the Human Resources Management Certificate. I want you to take a moment to reflect on the two questions presented on the screen. Pause for a moment and build your opinion around these questions. There is not right or wrong answer. Here's the first one. Business sometimes discriminate against their customers on the basis of sex. A bar may charge females a reduced or waived cover charge in a ladies' night promotion, for example, to increase the female ratio in their audience. Hair salons routinely charge more for services to women, and even dry cleaners charge higher prices for cleaning women's clothes. Do you believe these forms of discrimination should be illegal? Why or why not? And here's the second question. Research demonstrates that taller, more athletic, and more attractive people earn more in the workplace than shorter, less fit, or less attractive people. Do you believe this is unfair? And if so, do you believe the laws should be amended to protect these classes? Think for a moment and build an opinion around those questions. So pause, reflect, and then continue. Federal contractors are required to take affirmative action to compensate for historical discrimination against women, minorities, and individuals with disabilities. Federal contractors are required to develop and maintain a written affirmative action program that outlines proactive steps the organization will take to attract and hire members of underrepresented groups. This data-driven program includes analysis of the composition of companies' current workforce with a comparison to the availability of workers in the labor market. The inclusion of sex as a basis for protected status in the Title VII of the 1964 Civil Rights Act has led to additional areas of legal protection, and a number of laws and regulations now address discrimination based on sex or gender. Here are some of those additional areas of protection. Number one, the Pregnancy Discrimination Act, or PDA of 1978, amended Title VII to require that employers treat maternity leave the same as other personal or medical leaves. Closely related to the PDA is the Family and Medical Leave Act, FMLA, of 1993, which requires that qualified individuals be given up to 12 weeks of unpaid family leave, and also requires that those taking family leave be allowed to return to jobs. And also the Equal Pay Act of 1963, which requires employers to pay similar wages for similar work without regard to gender. Pay equity is the idea that pay should be similar for jobs requiring comparable levels of knowledge, skill, and ability, even if actual duties differ significantly. Before we take a break, I want to play with you for a little bit. Let's expand our knowledge on FMLA by answering the following true or false questions. So, the first question is, when an employee is on FMLA leave, the employer must continue the employee's health insurance but the employee must pay 100% of the premium, even if the employer normally pays some or all the premium. So what do you think? Is this true or is false? Think for a moment. So, if you were thinking false, you were correct. The employer must continue group health insurance coverage during FMLA leave on the same basis as if the employee had continued to work. This means that if the plan is non-contributory, meaning the employee pays 100% of the premium, the employer must continue to do so for employees on FMLA leave. On the other hand, if the plan is contributory, that is, if the employees pay some portion of their premiums, the employer may require an employee on FMLA leave to continue contributing on the same basis. So, here is the next question. True or false? An employee who is on FMLA leave has job protection, but when the employee returns to work, the employer can assign him or her to any available position as long as there is no reduction in pay. So what do you think again? Is this true or is false? And this is also false. When FMLA leave ends, the employer is required to restore the returning employee to the same or an equivalent position. Department of Labor regulations define an equivalent position as one that is virtually identical to the employee's former position in terms of pay, benefits, and working conditions, including privileges and status. One more question. True or false? An employee can legally be fired while on FMLA leave. What do you think? Is this true or is false? And this one is true. So I'm thinking that probably most of you thought that this one was false as well. However, this one is true. It is clear that an employer cannot discipline an employee because he or she is on FMLA leave. But nothing in the law prevents an employer from pursuing disciplinary action unrelated to the FMLA while an employee is on leave. However, for those who lived and worked in California, please be careful. California is a very pro-employee state, and although the law does not prevent it, I wouldn't necessarily consider a good practice to pursue disciplinary action while someone is on FMLA or any other leave for that matter. So I sincerely hope that the image on the screen does not represent how you're feeling at the moment. However, a break can never hurt anyone. So get a beverage of your choice or simply take a few minutes to stretch, appreciate the view, use the restroom, text someone you love, or just reflect on what you have been learning so far. Once you feel re-energized and recharged, play video 3 of this week. See you soon.